So good morning from London. My name is Yari Krivoy. I work for the British Institute of International and Comparative Law, where I run the Investment Treaty Forum. And it's my pleasure to welcome you to the second day of our event, of our forum on investor-state mediation. I think the first day went very well. I particularly liked the interdisciplinary nature of our discussions, that people who attend this event were very knowledgeable and engaged. And I hope that today we will follow the same pattern. So we will have a keynote address, which will start in a few minutes, followed by two substantive panels dealing with policy and practical issues, and then future of ISDS mediation, including issues of climate change, COVID-19, and other hot topics. And then at the very end, we'll have a group discussion about our next steps, where all speakers who spoke today and yesterday will join one panel, and we will be thinking how to take it further, what we can do next, building upon what we have already done. I should add that the video of this event will be published later online, so you will be able to go back and check those presentations which you particularly liked. And I would also encourage you to use the Q&A box, and if you could ask your questions a bit earlier, rather than wait until the very end, that would allow other people to read your question and like your questions. And so if there will be too many questions, then those questions which are particularly popular among our attendees will be asked. And we will connect, where possible, those people asking questions so that you can use your voice and your video to address the speakers. As I understand, you received an updated list of participants today, so I think we already have a good number of people, but some people are joining later, so they're not for the entire event. But the keynote address itself will be guided by Wolf, to whom I'm now transferring the virtual microphone. Wolf.
Thank you very much, Jarek, and welcome everybody to our second day. Hopefully today we will be able to build on our discussion yesterday, and we also would like it to be interactive, so do please send in your questions. One of the topics we discussed yesterday was the need for real mediation cases in investor-state disputes to be better publicized, so that both investors and states and other stakeholders could see how mediation was being used and was successful in resolving these types of disputes. And we know very many of these situations are not publicized, but we're very fortunate today to have with us Mercedes Tarazon, who has been active in this area and will discuss with us how an investor-state dispute can be mediated. Mercedes has many years of international experience as a mediator. She's the founding partner of Dispute Management located in Barcelona, Spain. She specializes in conflict management and resolution and international business law. She's a fellow of the Chartered Institute of Arbitrators, where actually I've known Mercedes for many years, both in arbitration and in mediation, and a distinguished fellow of the International Academy of Mediators. She has more than 25 years of experience in cross-border commercial mediation. She's also sat as a conciliator in investment cases and is in fact appointed to the ICSID panel of conciliators that Meg was speaking about yesterday. So today we're looking for Mercedes to discuss her experience as a mediator in investment state disputes. Earlier this year, Mercedes took part in a mediation between the Dominican Republic and a Brazilian company, Odebrecht. While we know that much, while we don't know that much about the case, again, because much of it is confidential, and we will also respect that confidentiality today, we'd ask Mercedes to draw on her experiences in that and other cases and discuss some of the key aspects of mediating an investor-state dispute. So Mercedes, with that, if I could turn it over to you.
Thank you very much, Wolf. Hello, good morning, good afternoon, good evening to everybody. And I would like to first start by thanking all the organizing entities for the kind invitation to participate in this forum. What I would like to do is to, first of all, address expectations, and Wolf has already helped me with that. Then make a brief summary of the facts of the Punta Catalina mediation, which is the one Wolf was referring to. Then talk about how I prepare for mediation, for investment state mediation, and things that help to my mind and things that don't help, that are quite frequent in these cases. When I say that I would like to address expectations, is that I am very clear, I will not be talking in much detail about the Punta Catalina mediation. And this is so first and foremost because I'm not entitled to. The fact that parties decided to issue a press statement does not release me from the obligation of confidentiality. And I mean, now parties are known, law firms are known, they are fully identified. And it would be very tricky to talk in detail about the case without revealing unintentionally who did what. But secondly, and it is also important, is that I don't think that entering in that detail would be that important in terms of sharing knowledge, because conflict is an objective reality. It's not an objective reality, it is a subjective reality. The parties negotiators bring their own views and ways of doing to the table. And if any of these people is substituted by someone else, everything can change. I mean, the dynamics of the negotiation, the way people interact between each other. So I think that it is not that precise case, but things that I have learned from this case and others that I think may be useful for this conversation today. So what I intend to do is to share details and reflections and lessons learned from the two investor-state mediations in which I have intervened as mediator, which is one is the Punta Catalina one, and the other is a previous one, which did not settle, but gave rise to an interesting decision of the Swiss Federal Court on when pre-arbitration proceedings are mandatory and what the sanctions are if such proceedings are not duly followed. Also on reflections on my own preparation before these two mediations. You do a lot on yourself, on the case, but also on yourself and conceiving how you will address things. And maybe things happen or don't happen, but all of this preparation is already experienced for yourself. And also my own debriefing after these two mediations, which is something very useful and that I do after every mediation. And also I would like to share lessons I've learned of my own preparation and debriefing of cases where I have acted as negotiator for a state. I'm not referring here as acting as a negotiation consultant for a state, which is something I have also done, but being really the action person in a mediation. I mean, with this what the state asks you to do is to be the one who sits in front of the other party and deals with whatever is said and done by the other party in the table of negotiation. It's not the same role as a mediator, but bearing in mind that as a mediator, I assist the negotiation, there's a lot that I've learned in these experiences that has helped me later when sitting as a mediator in investor-state mediation. Although I won't enter in the details, I think it's fair to make a brief summary of the facts of the Punta Catalina mediation because I don't know if everybody attending is familiar with that and has no problem with sharing that information. Parties were on one side, as Wolf has said, the Dominican Republic government through one of its state entities, Corporación Dominicana de Empresas Eléctricas Estatales, and on the other, actually it was a consortium made of the Brazilian company Odebrecht, the Italian very renowned engineering company Tecnimont, and a Dominican constructor, Estrella, who's very well known and renowned locally in the Dominican Republic. The project consisted in the construction of a coal-fired thermal power plant in the province of Peravia, the Dominican Republic, and the plant is named after the municipal district of Catalina. And that's why I call it the Punta Catalina mediation, because actually the project that was the object of the mediation was finalizing this thermal power plant. The conflict arose because investor was claiming nearly $1 billion as additional payment for extra cost it has incurred in the construction of the plant. For those of you familiar with construction cases, this is quite a common claim in construction cases. I mean, one thing is what it has been planted in on contract and budgeted and everything, and then there are many things arising, extra costs involved, and then often these issues end in arbitration or in hopefully before in a negotiation, but so it's quite common. It was an institutional case administered by the ICC International ADR Center and negotiated, and what we had to do, we succeeded in settling the case. The agreement consisted in the state paying less than half of the amount initially claimed and disbursing even less because there had been a contingent fund set up previously to secure continuation of the works, subject of course to the resolution of the disputes. And this contingent fund was of the essence because it simplified the payment in terms of budget issues. And by simplifying the payment, it simplified negotiation in a way. There's a point I have been asked to address, which I don't think is covered. I mean, I think I can share it because I mean there are no confidential issues involved in that, and is how I was appointed for that mediation. In that case, counsel for a party contacted me to ask for details of my experience in big construction cases, where I've seated both as mediator, but also often as arbitrator. And my experience on these kind of cases and all the details of my CV, as well as on my availability in the following weeks. And the reason for contacting me was that they wanted to include my name in the list of candidates that they had agreed to exchange with the other party. And parties negotiated with the names, and finally they agreed on my name. And as it was an ICC case, parties informed the ICC that they had agreed on my name, and formally it is the center, it is the ICC that appointed me. How do I prepare for an investor-state mediation? Well, before entering properly in how I prepare, I would like to touch upon an issue, the issue of whether investor-state mediation and commercial mediation are different or not. I am aware that my point of view may be controversial, especially in this forum. But as a mediator, at least in my experience, I don't think there are that many differences. When I say this is because, well, first of all, I do not compare investor-state mediation with commercial mediation. I am comparing investor-state mediation with international commercial mediation. And when you compare both, at least once again, in my experience as a mediator, I think that the differences are in degree, but not in nature. I mean, things are more sensitive, things are more complicated, but to me, the leap is quantitative. It is not qualitative. I am not doing things differently. I am taking extra care for everything. And I am already someone who takes a lot of care in mediations, but I'm taking extra care because things are far more complicated. But this is so in international. The fact that we have the international arena means language issues, cross-cultural issues. It is then more difficult for everybody to put in the other party's shoes to understand really what is being said, and things get more and more complicated, at least in my experience, once again. So how do I prepare? Well, first of all, I ask parties what they understand by mediation and what they think my role should be. And I say this because there is no common understanding of what mediation is. If you talk about arbitration, first of all, you will have a venue, you will have a seat of the arbitration. So you will have an arbitration act, or if not, the seat will be agreed and you'll have an arbitration act so that the parameters will be clear. But mediation and conciliation are terms that you find in different jurisdictions, also often with a long history. And actually, if you go, now it is more and more common to understand conciliation as a mechanism where the neutral proposes, makes a recommendation, and to understand mediation as a mechanism where the third person does not propose, does not make a recommendation. But actually, if you go, if you study the different conciliation acts or mediation acts that you can find in different jurisdictions, and I'm talking especially for countries in the African countries, Latin American countries, or even the conciliations in many European jurisdictions, you see that sometimes the third person is expected to make a recommendation and sometimes not. And sometimes mediation is where you make the recommendation and conciliation is where you don't make the recommendation and all those things. So first of all, I need everybody to be on the same page. I need them to explain to me what they understand by mediation and what they expect of me. I do believe that assisting and facilitating the negotiation is far more efficient, but I'm flexible as how to define my role depending on what parties expect of me. What with this, and because the scope of this is first of all to make sure that we're on the same page, and also to help parties to feel at home. In the international arena, it is important that everybody feels at home. So, but I ask what they understand by giving already ideas. So I say, do you expect me to do that, or do you would rather have me do that, and that? This helps because normally when parties are given they are given the option of me giving a recommendation, which can be a recommendation that does not favor their interests, or me facilitating, I get them to say that they would like me to facilitate. And this is important because I have already one agreement. And I say this because in the first mediation, the first investor-state mediation I mentioned, the clause spoke for conciliation. And these were North African countries, North African parties from different countries in North Africa. So, I mean, I've seated as conciliator in Morocco, and there you are expected to make a recommendation. So I really wanted them to, but by giving them the option and explaining them that there was this possibility of me facilitating the negotiation, that it came from them the agreement that I should sit with what we would call here a mediator. So I would facilitate a negotiation. Once this point is clear, of course, I need to understand what the conflict is about. And I don't have that much time. I mean, actually, you are appointed and then parties have already agreed that the negotiation will take place, the mediation will take place in the following weeks. There isn't that much time to really prepare for everything. So, but I need to understand what the conflict is about. I need to understand what they are discussing. Sometimes this is clear because, well, clear, I mean, you have enough information or you have a certain amount of information by what the party has explained in its first requirement for the mediation to go on, and what the other party has answered. But sometimes you don't have that information. So why do I need to understand? Because for my preparation, what I do is prepare a questionnaire, which is the same for everybody, for all parties, but where the answers are sent exclusively to me as mediator, and the answers remain confidential between the party and me, unless there is the agreement of the authorization by the party for me to share this information. And in this questionnaire, of course, I deal with interest, I deal with what if, I deal with BATNA, of course, not set with these terms, I mean, made it clear, but this is very, very helpful because normally the two mediations I'm referring to were in-person mediations. So we had agreed to meet for a short period, 2 days in whatever, and to negotiate there. You can't start negotiating without understanding, without having thought in advance how you will schedule the meetings and everything. It is not that what you think in advance is what exactly you do in real life, because then you face whatever happens, but at least it allows you to structure and to conceive the process you can do with those parties for that case, with the time you are given and all those things. A very important, we all know, very important thing in mediations is to be able to define who the stakeholders are and who the participants are. As a negotiator on behalf of state, I have been able to do this sort of thing. But in my two investor-state mediations, I had almost no margin of decision. I was given the name of the parties and the name of people who would intervene. Or if I was not given it, I mean, when I asked in my first letter to the first email to the parties, that it was important that we all know who was going to attend and which were the responsibilities for each person attending, and I got a list of names. And what do I do with that? Well, I do some research. I try to find out both for the people on the side of the investor, but also on the side, the people attending on the side of the state or the state entity, because it is important to know their background, whether their degree of responsibility in the ministry or in whatever, in that state entity, which positions they have held in advance they have held in advance in the public administration, because this gives me more information. This information is something that I checked, not as an examination, but I when we meet in person, I hold, of course, first the joint session. I will be dealing with this in a moment. But when I have the first caucus with each side, I do try to make them speak about themselves, not only about the case or the entity or the organization they represent, but about themselves. Because in mediation and in any conflict, and that goes for all cases, but the bigger the case or the more complicated, and the international case is always complicated, because if not, they would have settled in advance. There is in all those cases, there is not one agenda for a part. I mean, the agenda of the party A and the agenda of the party B. There is an agenda for each person participating, and this agenda goes together with the agenda of the party, and you need to make everybody feel comfortable and to understand and to realize things that may happen, so that you can, during the negotiation, because you need to be prepared to handle them. Another thing that I do in advance for the mediation is, when talking about the venue and what do I need. And of course, we need a room for joint sessions and a room for each party to have its room where I will be holding the private sessions of the caucuses. I always ask for an extra room. And this is so because often the delegations for each party are big. I mean, there are many people, many, I'm talking about 15, 20 people for each side, which is already a lot of people for dealing in a mediation. And also because technical and legal minds don't necessarily mix well. So it may very well be that we come to a moment in the negotiation where either I need to speak I mean, there are technical issues that we would like to address, and then it may be more efficient to have the engineers to meet. I mean, engineers from both parties or from different parties to meet in this extra room, which is a sort of short, limited joint session. I always invite the leading counsel to attend because to be there, not to speak, but to be there, because I mean, parties need to feel secure, and the role of counsel is of utmost importance, and the engineers, they know they are in a mediation, and it is good that the person is there. But when I say that technical and legal minds don't necessarily mix well, I mean that I'm a practicing lawyer. We tend to, because it's how our minds is educated, constructed, and how we argue. I mean, it's many things depend and many things are arguable. When you're talking of technical issues, there are many things, maybe they depend, but they are seen by the experts and the engineers and the architects and the technical people participating that there is one answer to that. So without the intention of being threatening, the legal way of thinking can become threatening for the experts or for the technical people. So when I need them to address freely the issues so that we can discuss, sometimes it is better to hold this way. And that's one of the reasons of the extra room. The other is that I may have the need to speak to the decision maker together with the leading counsel, not in front of the rest of the delegation. And then if I have this extra room, I can invite. This is important because when the negotiation is moving forward and you see that some questions are not necessarily objective ones, but because of the way the decision maker is looking at the case, you are not going to challenge that person in front of the delegation, but you can have this meeting. So this extra room may seem minor issue, but it has proven to me to be very useful. Other things that I do, I think that's what, in terms of preparation, that's as much as I can do. Once again, I haven't been given that much information, and I handle with what I have. And there you go and you meet with parties. Do I have joint sessions and caucuses? I do. I mean, I am among the mediators that keep on having the joint session at the beginning. I would say no matter what. I mean, we are there all, no matter how difficult the situation is, no matter how much they have discussed, we are all there to work together on the problem to try to find a solution. So at least there is a joint session at the beginning. There is a joint session where I repeat many things that I have already said in writing. And of course, these parties have already signed my mediation agreement, not the settlement agreement, the mediation agreement, the one where parties agree to mediate. And of course, the good faith participation, the confidentiality, all these issues are there. But all the ground rules are there. But nevertheless, I say them again because it's an extra of commitment for them to be there. And also because, as I've said, there are, in my experience, large delegations for each side, and not everybody knows everybody. So, I mean, there may be associates of the law firm, there may be other engineers that had not been in previous negotiations. So it's important that at least everybody knows who's the person they are meeting in the, they are seeing that are in the room. Elements that I think help in these cases and things that make it complicated. Elements that help, let's be very clear. One is the fact that the project execution is well advanced. The thermal power plant of Punta Catalina is made up of 2 power generation units. The first unit was already in operation when the mediation began. The case settled at the beginning of March this year, and the second unit came into operation mid-April. This is to give you an idea of the timing. So it is true that there were political interest involved because there was going to be general elections in the Dominican Republic, and the outgoing president wanted to be at the inauguration of the project because it has been one of the main projects of his mandate. But this said, I mean, you couldn't have had the inauguration if the execution was not clearly well advanced. And when the project is well advanced, the partner of each party is not that good. I mean, if they are going to an arbitration and everything is blocked. In the other mediation, the other investor-state mediation I've mentioned, the project was at its beginning. Another thing that is of the essence for the mediation to move forward, and it helps a lot, is that fact that you have counsel, the lawyers are committed to the process and participate in it appropriately. I have experience in international, also in domestic, but in international mediations, counsel simply not believing, let's put it this way and be nice, not believing in mediation and not helping any. And I mean, if you have them against the process, it is really, I mean, you can do it, but it is really very, very difficult because to challenge a lawyer in front of his client or her client is not the best way to move forward. So it is of the essence. It is of the essence. Difficulties that you encounter. Language issues, as I've mentioned. Sometimes, I mean, even if we are all speaking the same language and it is our mother tongue, this happens in English, it happens also in Spanish, that, I mean, the language in the same language, but spoken in different countries is different. So there are ways of saying things that there can be confusions with that. Previous negotiations, the people that go to a mediation, they have already dealt among each other in a previous negotiation that have not been successful. There is lack of trust, and you perceive that. I mean, maybe they tell you that expressly, but maybe they don't, but you perceive that. And then you have to build on that to be able to move forward. Then the adversarial approach. Even though sometimes, because it has happened to me, they told me about interest and they have done the negotiation program, Harvard's negotiation program and whatever, they know the theory, but they don't practice it. So they have an adversarial approach, a hard style, and they are asking constantly for concessions from the other side. And you need to keep these things under control because you need to move, you know that the way moving forward is another way. And then what I would call, and I'm being very low-key here, naughty behaviors. I mean, these tough negotiators, even when the deal is there done, I mean, they put an extra thing that will make the other party feel uncomfortable. And you feel that, and I found that as a negotiator for a state, and the state official asking me to ask the other party for something, or for instance, the signature of the agreement to be done in a way that, let's be clear, it can be perceived as humiliating by the other side, and you need to handle it. So what I do in those cases is that I either don't do it. For instance, if we are not moving forward, to send a proposal that is an insulting proposal because it is less than what has been on the table in advance, I mean, I simply say it makes no sense to put that proposal to the other side, and I don't do it. Or if it is this, what I'm saying, which is putting the other person in a way that, yes, they will get the deal, but it will be in a way that at least the forms will be humiliating for the other side or can be perceived. What I do is I put myself in the same situation I've been asked for. So the signature is done, but in a way where the other person feels that we are together there. Because you need to neutralize those things, and these things happen. I'm happy to take any questions I can take, and I hope that with this presentation, I have succeeded in fulfilling expectations, notwithstanding I have not entered in the details of the mediation.
Thank you so very much, Mercedes. That was fascinating and extremely informative. And I think given the discussions we had yesterday and also previously at Harvard, it actually reveals a lot about how an investor-state mediation is run, but also some of the subtle areas which are so important. I think, as you point out, each case will be different, but there are a process aspects, of course, that will be similar with respect to each case. And we don't actually have very much time for questions, but let me see what we have here. Yes, there is a question, and we've talked about that yesterday too, the transparency versus confidentiality aspects in investor-state cases, and the attention of the media to the case, because this obviously was an important situation in the Dominican Republic. How is that handled? How do you handle transparency versus confidentiality?
Well, let me say that transparency, this issue of transparency versus confidentiality in mediation is not exclusive of investor-state mediation. It is the case of any mediation, even the domestic ones, where the public administration is party. Because, I mean, public administration has some requirements, and of course, there will be transparency issues. But once again, transparency issues is not living in a building made of glass. It is being transparent on the fact that the mediation is taking place or has taken place, the settlement reached. The government will most probably need to explain how the money will be paid in terms of budgetary issues to make it clear to the society. But the core of the confidentiality, which is what happens, the information that is shared in caucuses, the details, they remain confidential. And by remaining confidential, they are not putting at stake any, I mean, the requirements or the public requirements of transparency. That's something I contrast constantly with the state party and also with the investor, because sometimes they say something and you need to make clear, I mean, this sort of information, the state will need to make it public. So let's find a way, and it can be handled. It can be handled. But once again, it's not a requirement exclusively, or it's not an issue exclusive of investor state. It's an issue of no matter which mediation where the public administration participates. And the issue of press releases or the media being interested in that, this is, you are there to tell the parties if they need assistance with that, and sometimes you find that they would like you to assist in drafting or in how to word the message that it can be sent to the public, that it does not uncover information, but it is a reliable thing, so that there is no hidden information or double, and sometimes, I mean, you need to be aware of them.
Yeah, thank you, Mercedes. We could probably spend all day on this. Unfortunately, we have to move to the next panel. So thank you so very much. Really appreciate your taking the time with us this morning. And I hope that you can stay for the rest of the forum. And
I would love to. I will have to miss the next panel because I'm in a mediation now and I need to, but I'll be back. And I will read the comments that in the questions, and if there is an extra moment where I can deal with that, I will try to give an answer to that.
Thank you very much. That would be greatly appreciated. We're now going to move on to panel 2. We have to set up the panel, so if everybody would give us a few minutes, and we'll then move on to panel 3, and we'll then move on. So we'll just take a few minutes to set up the panel.